Good afternoon, everyone. Thanks for being here this week. Sorry we're maybe a couple minutes late getting started today, but apologize for that. Let's just jump right to the agenda since we're already at 12:03. We, as usual, have four presenters for you today from across our practice across New York State. We're going to start with something that pertains to our university and higher education clients. Krista Cook from that practice group here in Syracuse is going to talk about the revised Title IX regulations and some updates for those who need to be complying with those. Some important information there. Then we're going to move to Buffalo with our senior counsel out there, Mark Krawick, who's going to talk about artificial intelligence in insurance underwriting and pricing. It seems that we can't go very long without a presentation about AI these days because it's really touching everything. Next, we're going to hear really what I'm really looking forward to, a special presentation from Alice Stock from our New York City office and our Labor Department, who had the great honor and privilege of testifying at a congressional hearing recently about the NLRB. And we're going to hear about her testimony and kind of she's going to give us a look, as she says, under the hood as to what it's like to testify before Congress and what might come of that. And then finally, I mentioned this a month or so ago, but Nick Jacobson from our our Rochester office is going to be giving us a regular update about every month, interesting litigation cases that we think our clients would learn from. So he's got a couple cases to talk to us about today. So that's our agenda. I appreciate all the presenters being here today. I appreciate all the attendees. So let's get started with Krista. Go right ahead, Krista.
Thank you, Kristen, and welcome to everyone who's joined us. Thank you for joining us again today for our webinar. I am going to spend a few minutes addressing, as Kristen mentioned, our university and college clients out there who have spent this summer wrestling with the revision to the Title IX regulations. We want to take some time, just a brief update so we're where we are on the Title IX regulations, and give you folks a reminder on, now that you have your policies in place, other compliance mandates that you need to turn your attention to. So before we do that, I'm going to do just a quick overview. Kathy, if you could turn to the next slide. So back in April 19th of this year, the Department of Education finally released the revised Title IX regulations. These Title IX is a federal statute that has been on the books since 1972. It prohibits sex discrimination in schools and universities that receive federal funds, including the prohibition of sexual harassment and sexual violence on our college campuses. The new regulations announced this year come after years of planning. They are long awaited. We didn't know if we would get here, but we are. And the regulations clarify a very important and significant change in the law. Specifically, they clarify that discrimination under these new regs covers discrimination on the basis of sex stereotypes, sex characteristics, pregnancy and related conditions, sexual orientation, and gender identity. So we have a much more expanded scope of these Title IX regulations, which has in turn required institutions out there to revise their policies to comply with that expanded scope. One mention, the revised regulations are not retroactive. So all of your new policies and procedures will apply discrimination and harassment occurring on or after August 1st of 2024, regardless of when the conduct is reported. So the 2020 regulations and your policies that were compliant with those Title 2020 regulations will continue to apply to your institutional responses to conduct and incidents occurring prior to August 1st. So there will be a slight period of time where there'll be some overlap in your policies. You'll have to have both policies sort of on your books or on your website. But that's sort of a background of where we are, where we've been and where we are now. Next slide, Kathy. I want to take a quick minute because many of you have been watching this. We have tried to keep you updated on this. There's been significant challenges to the 2024 Title IX regulations. And I know a lot of our college and university clients have been watching this. At least 6 federal courts have issued injunctions barring enforcement of the new regulations. And that has turned out to be enjoin about half of the states. New York is not one of those enjoined states. The continued court cases have caused some level of continued confusion to the extent that, for example, the U.S. Court of Appeals for the 11th Circuit issued a very broadly worded injunction that led some uncertainty as to its scope, and raised some questions about whether or not that it created a nationwide injunction, which has been the question sort of looming with this patchwork of court injunctions. The Department of Education has stepped in amongst this sort of patchwork of injunctions and announced that it will not require schools that are subject to those 26 state-based injunctions and are identified on a list filed with a Kansas court that, due to a student or parent's membership in a plaintiff organization, neither of those will need to be enforced under the Title IX regulations. The Department of Education has made it clear they will not enforce the new regulations upon those institutions. Now, that list of institutions that might be impacted is anticipated to be updated. So this is a very fluid and evolving area. We will try to watch for you. But all other schools, the Department of Education has made it clear that all of their schools that are not subject to these injunctions are expected to have already be in compliance with the regulations back on August 1st. Next slide, Kathy. I'm not going to go through the slides in detail. Certainly they will be on our website, but I wanted to provide sort of just a very quick hit on some of the big policy changes that all of you have had to implement. One of which, under the new regulations, is the expansion of the definition of sex-based harassment. The definition of sexual harassment has changed, as well as I mentioned, the coverage and scope now covers harassment on the basis of sexual orientation, gender identity, and those types of areas. Sexual assault, dating violence, domestic violence, and stalking, all of that continues to be covered under the Title IX regulations. Next slide, Kathy. One of the very significant changes in the Title IX regulations is the expansion of what we call maybe mandatory reporters. Under the revised regulations, all of you have had covered under the Title IX regulations have had to revise your policies to address this expansion within the regulations, so that all non-confidential employees on your campuses have some level of a reporting obligation. And those with responsibility for administrative leadership, teaching, advising, or those with the authority to institute corrective measures. And notably, faculty would be within this group. Those individuals on our campuses must be required to notify the Title IX coordinator when an employee has information about conduct that could reasonably constitute sex discrimination. The second tier are individuals who are not covered by that classification have sort of an option, and they are obligated to notify the Title IX coordinator or provide the reporting individual with the Title IX coordinator's contact information and information about how to make a complaint to the school. Notably, you as an institute, the colleges had the discretion to choose one or another with respect to that second class. But this is a significant area in which your policies will change and the implementation within this area will change. Next slide. The last piece that will change significantly is with respect to your adjudication procedures. the 2020 regulations required a one-size-fits-all model, and that has significantly changed under the revised regulations. Now institutions had several points of policy choice and could decide whether to use a single investigator model, a hybrid model, or live hearings, and how to conduct the questioning at those live hearings. The point here is that your grievance procedures implemented in response to these revised regulations will likely differ significantly from the procedures that you had in place over the last 4 years. Many institutions will have multiple variations or within those grievance procedures for different areas of their, for faculty or students or employees. So there will be significant change, and we'll need to educate our campus communities of all of these changes. Next slide. So we wanted to take an opportunity now that the colleges and universities have rushed to digest the regulations and revise your policies. We want to remind you that we now need to focus sort of to the next phase of making sure that we're compliant with the training requirements under the revised regulations. The training requirement has expanded extensively. It now requires that all employees on your campuses must be trained on certain things, such as how the institution's obligation to address sex discrimination, what constitutes sex discrimination, and the issue that I just discussed earlier about mandatory reporter obligations. We will need to train our employees of their responsibility to notify the Title IX coordinator and to provide the Title IX coordinator's contact information when an employee's information about conduct that could constitute sex discrimination. The other piece of the training that will need to be conducted is to train employees on their responsibility to provide a student who has disclosed her pregnancy to the employee with the Title IX coordinator's contact information and other information to advise them that they have the availability and right to reasonable modifications. Next slide. Now, there's a whole separate group of individuals within your campus communities, the Title IX coordinator, investigators, decision makers, and individuals who are involved in the informal resolution process who will need to receive an extended, more expansive training requirement. And over the next 2 slides, I've included some of that information. What these individuals will need to know certainly is a very detailed information about what your grievance procedures are under the revised regulations. You likely have 2 pieces under 106.4.5 as well as the 106.4.6 procedures for sex-based harassment involving a student. Those would include sort of your sexual assault reports involving a student. So these training requirements will take some time. Certainly, fall is a very busy time on our campuses. And so we wanted to remind you of what will be probably a time-consuming process, right? To get all of not only the entire group of all of your employees on campus trained, but to also train this group of your Title IX coordinator, investigators, decision makers, so they have a in-depth understanding of how the policy has changed, how the law has changed, and how to implement those issues, including sort of the change in how to evaluate the term relevance and what's impermissible and permissible, right, evidence in these proceedings. Next slide. And you can skip to the next slide. So the training must be completed within 30 days of when an employee is hired or when they change into a new role, and also annually thereafter. So this training, again, as I mentioned, is significantly more cumbersome than under the previous Title IX regulations. You will need to be mindful about which groups of individuals on your campuses need what type of training. And we advise, remind you that training must be completed, not just made available, particularly with respect to that large group of sort of all employees. Next slide. And so that vein, try to find a way that we can confirm or document that training has been provided. While the revised regulations don't require role-specific training for your confidential employees, that's recommended, probably best practice, so that they're aware of their specific responsibilities under these new policies. And a final thought, the training materials are no longer required to be posted on the institution's website, but they must be made available for review to the public upon request. Certainly reach out to any of the Title IX team here at Bond if you need assistance with your Title IX training, including Laura Harshbarger, Phil Zacchio, Jane Sovereign, Seth Gilbertson, and myself. Thank you. Kristen, back to you.
Great, thanks, Krista. Lots to think about for those in the higher ed world. Let's move on to the next presentation from Mark on AI. Thanks, Mark, for being here.
Hi, thanks for inviting me. My name is Mark Krawick. I'm senior counsel at Bond. I work out of the Buffalo office. I'm relatively new here. I joined a year ago next week, and I came to Bond from a health insurer. Spent about 7.5 years in that industry. Worked for about 4 years at a bank before that, and in that role, in addition to sort of the traditional banking stuff, I had oversight of an insurance agency or a series of insurance agencies that we own. And before that, I started my career in private practice as a business and corporate lawyer. So I have and continue to do a lot of work in the insurance industry. Whether that's on the health insurance side, property and casualty insurers, or insurance brokers and agents. Can we go to the next slide? So I'm here to talk about a relatively new development that comes out of the regulatory body in New York. It's a circular that was published about a month ago by the New York Department of Financial Services, and it's called Use of Artificial Intelligence Systems and External Consumer Data and Information Sources in Insurance Underwriting and Pricing. For purposes of this discussion, I'll probably, in some cases, just refer to these as like AI tools. There's a technical difference between an AI system and an external data source under the circular. But I think in terms of considerations and obligations, they're mostly treated the same. So just as some context, the industry, I think, knew something was coming from DFS for a while, probably going back to about a year ago or maybe a little bit later last fall, but weren't sure exactly what was going to be coming out. This publication was issued in draft in the middle of January. There was a 2-month comment period that closed in the middle of March. And then DFS, thought about, analyzed the comments they got, and they issued the final publication July 11th of this year. So, I guess to start, what does this apply to? As the title suggests, this applies to underwriting and pricing. So, there's a lot of potential applications in the insurance world when it comes to AI tools. I suspect that this is just the start of regulatory action as it relates to AI in the insurance world. And I think DFS focused on underwriting and pricing because those are two areas that really have a direct and immediate impact on customers. What this doesn't apply to right now, things like claims processing, things like customer service, case management. This particular circular wouldn't apply to that, but I think a lot of the principles in it will be extended to other areas, in the relatively near future. Part of the reason I think that is that there's a group called the National Association of Insurance Commissioners, and they publish model laws, model regulations. Some states adopt them word for word, other ones adopt them, with some modifications. But the NAIC published a model AI regulation in December of last year, and that regulation had a more broad scope, and it specifically references case management, claims administration, payment, fraud detection. So I'll talk about in a couple minutes a couple components of the New York circular that are based on almost word for word the NAIC guidance. So that's part of the reason I think there's probably more to come. One of the things that I keep referring to this as a circular, and that's because it's not a law, it's not a regulation. There are, some, I think, legitimate questions about what this actually means. And during the comment period between January and March, there were some comments from industry groups that said as much and sort of said, if DFS wants to make regulation, it should issue a regulation. But right now, this is, just sort of opinions on what the existing law or regulations may mean. And if you look at the actual language in this circular, you will see a lot of instances where the word should comes up, and I don't think any, at least as I recall, where it says you must. So technically, I think there may be some validity to those questions, comments around what this actually means, but in a practical sense, if you're a regulated entity, there's very broad regulatory investigative powers of DFS, and if they're doing an audit or an investigation that relates to the use of AI, they're going to expect that these principles be applied. Can we go to the next slide? So there's three main components to this circular. They're around fairness, around governance, and around transparency and disclosure. I'm assuming most of the folks on this call are not working at a licensed insurer, and that the stakeholders may have other contacts to the insurance industry, primarily as a customer, whether it's commercial or individual, or as a service provider, who may be selling products and services in the industry. So I'm going to try to approach it from that perspective. I'm going to skip over the governance stuff because I think that's pretty much unique to insurers, who are licensed. Can we go to the next slide? So on the fairness theme, there's three main components. First one is data validity. So the circular is very clear, and this is true not just in the New York circular, but any regulatory guidance from any insurance regulator across the country, to the extent they've talked about AI, pretty much the number one thing is you are responsible for what you use. You can't just say, I bought this from a third party, or I don't know how it works, or it's complicated. If you're going to put this into production and use it in your operations, you're responsible for how it works and what it does. And so, one of the I'll say requirements of the circular here is that when it comes to data validity, insurers have to have a procedure to report and remediate any incorrect information that goes into these AI tools or these third-party data sources. So if you are a service provider in this industry, and the insurer is being told by its regulator that you, the insurer, are responsible for these tools and you're responsible for the data, I would expect that when the licensed entities are buying products or services from their suppliers, they're going to pass those obligations through. And in fact, the circular, in addition to reporting and remediation obligations, it goes on to say that these insurers have to develop procedures to eliminate incorrect information. So when it comes to due diligence, when it comes to contract negotiation, I think you will see, if it's not already happening, you will start to see that the customer in those arrangements, the insurance company, is going to start asking suppliers for more specific representations and warranties around the nature of the data, how tools are built, how they're trained, what the expected outcomes are. because they're going to be held accountable to that if there are problems or if there's an audit from a regulator. Another consideration is, if you're in that role as a service provider, if you're not building these things entirely on your own, but you're relying on third parties for some or all of the components that go into the products or services you're selling, you probably got to think about passing those obligations on to your suppliers or subcontractors as well, because I think everybody in this equation doesn't want to be the one who is stuck with a responsibility, whether it's regulatory responsibility or whether it's contractual responsibility to do something or fix something, and you're not in a position with the third party you rely on to be able to do that. When it comes to non-discrimination, so in the circular, again, there's a lot of responsibility on the insurers. And one of the things that DFS says is you shouldn't put these things into production unless you have determined that the system does not collect or use criteria that would constitute discrimination or an unlawful trade practice. Those discrimination, unlawful trade practice rules, they've been around forever, decades. Pretty much every state has them. And they're very broad, and they're the kind of rules that give regulators a lot of enforcement authority. So, again, the insurer is expected to know how these tools work. And part of that comes from the due diligence they're going to do with their suppliers. So, in addition to understanding data validity, in addition to understanding the inputs that go in to ensure that the outputs are not going to be unfair or discriminatory, there's also an obligation to do actual testing, statistical analysis of the expected outputs of these AI tools, but also a qualitative analysis that is, you just need to be able to explain how this thing works, what it does, what it's expected to do, if it's updated, if it's modified, what those updates have done, and how it might impact, the customer in the industry. So, again, I think those obligations being applied to insurers are going to be passed down primarily contractually to other entities that are, operating in the industry. Can we go to the next slide? So, the third theme that I mentioned a couple slides ago was transparency and disclosure. And this is the one I think that has more of an impact on the customers, again, whether they're commercial customers, individual customers in the insurance industry. So existing insurance laws, whether you're in the property and casualty line of business or health and accident line of business, there's obligations that have existed for a while that talk about what insurers have to do when adverse decisions are made with respect to their customers. And that can be a non-renewal, it can be a cancellation, it can be in some cases a change in rates. And in general, these are there because they're there to protect the customer, to ensure that decisions aren't arbitrary and capricious. And when you are applying AI tools, which I think necessarily mean less human involvement, there's obvious concern, risk that these things may not produce the outcomes that you expect them to produce, and as a result may have some sort of unfair discriminatory impact. So one of the things that this circular talks about is additional disclosure obligations by insurers. And those include disclosure as to, in a situation where there is an adverse determination that impacts the customer, disclosure as to whether an AI tool was used in the underwriting or pricing process, disclosure about what data the insurer used and whether that data came from a third party, and the right of the customer to request the specific data that resulted in the decision. I participated in one of these seminars a couple months ago, and I think I talked about a case out of Louisiana where there was a number of non-renewals of property and casualty policies as a result of crime scores. And the long story short version is there's a huge prison in this town, and there was crime happening within the prison that resulted in a bad crime score for the town, even though that crime actually had no impact outside of the walls of the prison. So, understanding the nature of these tools, the data that goes in, and not only understanding them, but getting specific representations, warranties from suppliers, and then getting commitments from suppliers to be transparent, to work with the regulated entity in the event of investigations or audits. I think there's going to be a lot more of that coming. And I guess my conclusion would be, probably if you're in that industry or you work in that industry, to probably start thinking about how that might impact the requirements of the contracts and the allocation of risk, responsibility, liability under those agreements.
Great.
That's it. Thank you.
Thanks, Mark. One thing that struck me is it sounds like, although AI is supposed to reduce the amount of work for us humans, this seems to be creating more work, at least up front,
Yeah.
correct?
Well, the governance part I skipped. There's a lot of it in there.
It's a lot of extra work. Okay,
Yeah.
great.
Right.
Well, thank you so much.
Thank you.
Great. So we're going to move on to the next piece of our agenda, Alice Stock, down in our New York City office. For those of you who don't know Alice, she joined the firm, I don't know how long ago, you can tell us, but she was actually Deputy General Counsel for the NLRB. So she was inside. We spend so many minutes on this webinar talking about what the NLRB is doing. Alice was there for many years. So she can tell us a bit more about that, and then how she ended up, talking to Congress about these issues.
Thanks very much, Kristen. Thank you for having me. I was asked to testify at a congressional hearing that took place on June 12th about the performance of the NLRB under the current board chairman, Lauren McFerrin. And it was entitled NLRB Overreach, Trampling on Workers' Rights and Fostering Unfairness. This was held before the Subcommittee on Health, Employment, Labor, and Pensions, which is known as the Health Subcommittee of the House of Representatives Committee on Education and Workforce. I was invited by Chairman Bob Good of that committee, who is a Republican. Now, I assume I was asked to testify because of my prior role as Deputy General Counsel of the NLRB. I joined Bond at the end of 2021, and I was Deputy General Counsel from 2019 to 2021 under General Counsel Peter Robb. I was also General Counsel for one day, so I hold the record for being the shortest serving as well as shortest General Counsel of the NLRB. The Deputy General Counsel position is really two full-time positions. It's you're really the COO of the agency because the General Counsel's office runs 90% of the agency, including human resources, operations, administration, finance, as well as many different legal arms, such as operating the regional offices. And the Deputy General Counsel has that role, as well as being legal advisor to the agency and legal policy advisor to the General Counsel. And in addition, since I've been at Bond, I've spoken and written articles in national conferences and publications on the operations and decisional trends of the NLRB. The other witnesses invited by the Republicans were former board chairman John Ring and a professor John Seaton from Minneapolis. Elaine Goldsmith, a lawyer representing unions in San Francisco, was invited by the Democrats. We all had to submit written testimony several days prior to the hearing. Mine was actually 25 pages single-spaced, which I produced between May 28th and June 9th, very intense period. And then at the hearing, give a 5-minute oral summary of the testimony and answer questions by each representative on the committee. And each representative has 5 minutes to ask questions. There is a YouTube link to the hearing and testimony and questions on Bond's website if you're interested. And I'm sure many of you have seen hearings on more controversial issues. As you know, many of the questions are asked as speeches in a leading way. But the reason I wanted to talk about this was because the whole experience was a very good look under the hood of the policies and decisional trends currently at the NLRB, the political reactions, and what is happening in Congress about what is happening at the NLRB. So to give you some background as to why this hearing took place at all and why now. So the National Labor Relations Board is made up of 5 members, 3 appointed by the president then in power and 2 by the opposing party. And these are Senate confirmed positions. The confirmation process usually happens in a kind of package deal where one party says to the other party, well, we'll vote for yours if you vote for ours. And that is, that's why you typically have 2 names going forward and confirmed at the same time. But that didn't happen last year. In December of 2022, John Ring's term expired, and there still has not been, that position is still vacant more than a year and a half later. And that is because last year, when Wilcox was being reconfirmed, the Democrats did not agree to a package. They just pushed her through with 51 votes. So now Chairman McFerrin's position term will expire at the end of December, and Biden wants her reconfirmed early before the election to ensure that there'll be a Democratic board majority through 2026, no matter what happens in the upcoming presidential election. Needless to say, the Republicans don't want this to happen, and they are looking to either scuttle her reconfirmation or delay it until after the election. But if this is voted on in the Senate, why is the House holding the hearing? The reason the House is holding the hearing is because the Republicans are a majority in the House and not in the Senate. And if you're in a minority, you don't control the agenda of your committee, and you get half the staff of the majority, so you don't have the bandwidth to do the reports or do the legwork. So this hearing, what this hearing was really all about in the House, was for the House to do the legwork and provide the evidence and ammunition to the Senate of the problems that are happening in the NLRB and its operations, and which are pretty rampant. You know, while there have always been policy changes with a change in administration, and in NLRB decisions, the changes have been pretty minor, and the pendulum has not swung that far. And the body of law has been relatively stable for many decades. However, law changes started occurring in the Obama administration, which was very pro-union. The Trump board tried to reverse that and reinstate the old policies to just get them back to where they had been prior to the Obama administration. However, the Biden administration has gone way beyond the Obama administration and has an agenda that is really not only pro-union, aggressively pro-union, but anti-employer and surprisingly even anti-employee, especially if employees' interests do not align with union interests. One of these areas, key areas where they don't align, is in secret ballot elections. So the clear agenda of this board is to eliminate secret ballot elections and to impose unionization through recognition. That's authorization cards that unions collect without any supervision or controls. And in addition, a lot of normal rules are changing so that many things that have been lawful for many decades are now all of a sudden unlawful. And there's so much more uncertainty now as to what the boundaries of the law are. So the NLRB's two main functions are to conduct secret ballot elections and to investigate and resolve unfair labor practice charges. And the board is supposed to, of course, adhere to the Constitution and Supreme Court rulings, adhere to the text of the NLRA, not make changes in the law through decisions, but to what they call color within the lines of the law in its decisions. And of course, to act neutrally, impartially, and even-handedly, favoring neither employers or unions. Well, this board has not hewn to any of these principles, and the three Republican witnesses discussed various aspects of that. I discussed the elections and that about the board's policies, particularly in the Cemex construction case that came out last year, as a prime example of the board's effort to disenfranchise employees. There is a new regulation that I believe you heard about a couple of weeks ago that will go into effect on September 30th. That's another example of a board imposing union representation on employees without an election based on a mere assertion of by a union of majority support. There have also been reports coming out. I'll just go to the end here. Two interesting things at the end of the hearing. First one, at the end of the hearing, when we were off the record, some of the representatives came to shake our hands and thank us. There was a high-ranking Democrat who came to us three Republican invited witnesses to say it's such a shame we can't have a candid conversation about these issues. I would love to hear your thoughts about how to fix these issues. And it is unfortunate that the angriest voices of the parties are the voice of the party. And about a month after the hearing, the Republican Senate Help Committee members issued a statement that they wanted a hearing on McFerrin's renomination, meaning they didn't want to rubber stamp her reconfirmation and wanted hearings about the operational and policy problems at the NLRB. So the purpose of the hearing from the Republican House Committee point of view seems to have worked. Thanks very much.
Alice, thank you so much. I didn't mean to rush you. We're a little over on time here, but for those of you who have stuck around, that was really a treat. I mean, really fascinating stuff. And thank you, especially that ending there. I mean, it's
yes,
you know, that you know that you had some success there in getting through to folks. You know, we're definitely out of time here. We were going to have one more presenter here today, but I don't want to overstay our welcome on this webinar. So we're going to ask Nick, if you don't mind, could you come back another week?
Yeah, absolutely.
Okay, great. So Nick's got some good stuff, and I don't want to run over. I know people have to get back to work and, you know, finishing up their lunch hours. So thank you all for being here. Thank you to our presenters who had so much interesting information. Here's the contact information for our presenters if you'd like to reach out with a question. This presentation will be posted on our website, and tune back in every week at noon on Tuesday, and you'll see Nick back here soon. Okay, thanks everyone. Have a good afternoon.